closely. We might not jump right on the question as we got to let everybody get through where they need to, but we will get your questions and we appreciate you being here today. So I'm going to turn the time over to Brian Morgan to get this thing rolling.
All right, thanks, Ryan. Appreciate it. Good morning, everyone. It's great to be here with you virtually. You know, it's such a strange feeling when you're used to speaking and teaching at large events. It is so strange to do this electronically. So it's nice to be able to kind of feed off the audience and know what you're engaging in and what you're not. And when we don't have that ability to interact, it makes it a little tough on our end. So hopefully, as you have questions, don't hesitate to ask the questions. I know there are places on your screen you can click to ask questions, but we will appreciate that, the interaction, even if we can't see you. And by the way, Ed from 5-Star, I was on a camp out several years ago with a couple of twins, and they came running back into camp with their shirts off, and their shirts are in their hands, and they're like, "Hey, we caught a couple bats." they found a tunnel where some bats were in there, and so I have a couple great potential employees for you if you need some. So thanks to all of our sponsors. We appreciate each one of you. So as mentioned, we are going to be talking about the FHA today. Now, I know over the last 6 months or so to a year, we've had a lot of discussion on FHA issues. Mostly it's been, or a good portion of what we've talked about over the last year or so has been service animals. And that's only one small aspect of the Fair Housing Act. So I appreciate Ryan's comment that it does cover a broad array of topics. And so we're going to jump right into the topics today. Our first one, and Ryan, I'm trying to click and it's not working. Advance that. There we go. So a couple of just quick items to give you the full background of the Fair Housing Act and what it does. First off, Title 8 of the Civil Rights Act of 1968, it created federal enforcement mechanisms on sellers and landlords from discriminating against buyers and renters. Now, it has long been established that the Fair Housing Act does apply to homeowner associations, community associations, both condominiums and planned communities. So it is applicable to us, unlike the ADA, Americans with Disabilities Act, which only applies under certain circumstances. So I want to just kind of give that distinction right up front, that even though it says landlords and sellers, for the purposes of a lot of the provisions in the Fair Housing Act, community associations fall under the purview, in essence, of landlords, somebody that is providing housing to other people. Let's go ahead to the next slide. So there are several protected classes under the Fair Housing Act, and under the Federal Fair Housing Act, the protected classes means you cannot discriminate against somebody based on race, color, religion, sex, disability, familial status, or national origin. Now, we actually had a landmark Supreme Court case come out this past week, and we can now, in essence, add to this protected class sexual orientation. That was a pretty dramatic case that came out talking about employment issues, but it will certainly be expanded to include other areas now that, in essence, the LGBTQ community has been declared a protected class by the Supreme Court of the United States. So that was a fairly landmark decision. Also in Utah specific, we have gender identity, sex preference, which again now will be covered under federal law as well as source of income in Utah. So
it seems like source of income is a little misleading. It seems like a pretty broad category, but it's actually pretty narrow. I always think of source of income, it sounds like, you know, no matter where you make your money, if you're just living off of SSDI or child support, but that's not it. It's really strictly Section 8 vouchers. So it's not unheard of, but it's fairly rare we run into that in community associations. at least in Utah.
Perfect. All right, let's go to that next slide. So one of the things, and I'll let this, Laura, I believe this is your next slide, right?
You know, I don't have a, I can't run the PowerPoint. Oh, no, this is
Oh, I'm sorry. Okay.
Extremely slow.
Yeah, so one of the things that we don't talk about a lot is fair housing, the funding by the FHA. So the FHA does provide funding, and for condominiums, it's a little unique. If you're in a single family home, you can get an FHA loan, and some great benefits to the FHA funding is you don't have to have the 20% down. You don't. There are a lot of benefits to obtaining fair housing funding from the FHA. And but if you live in a condominium, historically there have been significant requirements that you have to pass, or the condominium actually has to pass in order to qualify for FHA funding. And it's quite a lengthy process to go through and to get your condominium approved globally for fair housing funding. And again, over the years, they've modified that a little bit on the way that works. They've changed it so you can get ongoing continuous funding as a condominium. There are ways that you can get short-term approval for a section of a condominium, but most recently, in fact, just March of this year, before COVID hit, they were able to pass. And by the way, CAI was very instrumental on a national level in helping get this bill passed. In fact, I remember being in Washington, D.C. last year, I believe it was in the spring, where we met with all the legislators that were involved in this fair housing bill, and talked to them about some of the benefits of doing what they ultimately, what they're continuing to work on. This actually was through executive order, this most recent thing in March. But what they have done, they've actually allowed for individuals to obtain FHA approval, loan approval, which is pretty extraordinary actually when you look at the history of how this has worked. So what that means, you as an individual, anyone living in a condominium can go out and still try to obtain an FHA loan, even if the condominium has not been globally approved. A couple requirements that have to be met if you're looking for FHA funding. The development must be completed, cannot be under construction. No more than 50% can be rentable or investor owned. So historically, what we've had to do in helping condominiums comply, we have to keep a list of who lives on site and making sure it's owner occupied, as opposed to who rents out the units. So that's one of the requirements. You have to kind of have that information readily available. So even as an individual, you're going to have to know those numbers. And where that PowerPoint says must buy and reside, meaning you buy the unit, but you also have to reside there to obtain that FHA funding individually, but also over no more than 50% can be rented out. Also, it must be ensured that at least 10% of the HOA budget is in a cash reserve. So that's one of the requirements, that if anybody is looking to do it individually, they're going to have to go through the same process and make sure that they can get financials and prove to the FHA that there is an adequate reserve. And then finally, no more than 35% can be used for commercial use. So that would be in mixed use developments, condominium. This is sometimes more applicable when you have high rises and they have a lot of the facility is used for commercial, but only 35%, no more than 35% can be used for commercial purposes to obtain that funding. So those are the requirements. There are companies, banks that help set up an entire condominium to qualify for fair housing funding, loans, and like I say, we've done many of those over the years as well. So I think that is it on that slide.
I do have one question that's come in. They're asking for you to expound upon insured and at least 10% of HOA budget must be in cash reserve, the 10% of the HOA budget. They're just asking you to kind of expand on that a little bit.
Okay, perfect. So if basically what you have to do on that, you have to provide a budget, an annual budget, and you have to be able to establish that at least 10. So if your budget is $100,000 in a year or $1 million, let's say $1 million for a condominium, then you have to show that $100,000 of your annual budget, or $100,000 in this case, is in cash reserve. So that could be like CDs. It could be places where you can access. It's fairly easily accessible with minimal difficulty in getting that. It doesn't have to be a formal reserve account per se, but you do have to have that in fairly liquid funds for that. Insured, a couple things that you have to look at there. One, you have to just, number one, check your documents and find out what your insurance requirements are on that. And then also in compliance with any requirements statutorily. And typically to show that you've met those requirements, the FHA generally requires some kind of formal opinion letter from your legal counsel to show that you have met all those requirements and that your CCNRs actually allow you to divulge that information and allow you to, in essence, confirm that you're able to get that funding.
Perfect. We do have a couple more questions. Do remodels impact the not under construction?
That's a great question. No, it's basically certificate of occupancy from original construction date. So if units are under remodel, that's okay.
Perfect. One more question. Can the current owner get FHA funding approval, or is it the new buyer?
The current owner could as well. If they were going to refinance, then they would just have to go through those same requirements. And by the way, so I have not had a chance to read all the way through the March 2020. It's about a 50-page document that they came out with, and it has the main principles are kind of the bullet points that I have right here. But they also have a lot of comments, a lot of questions, and so I haven't had a client yet that has asked about that specific issue. And typically that's where I kind of get into the weeds on some of those details, but it's about a 50-page document, and most of it is focusing on this new provision where they allow the individuals to obtain that financing.
Perfect.
So we're gonna whiplash all of our audience here and take a totally different topic on, and that's one of rules. So, you know, our goal today was to address kind of the big new issues and some of the problems that we're seeing. So I want to talk kind of broadly about creating and enforcing rules in the condo association, because, you know, these are apt to change pretty quickly, where boards can adopt rules on their own. We don't need 67% approval, and sometimes those rules are where associations really get into trouble. So again, really get familiar with those protected characteristics. It's something that should be on your mind, at least something that you can recall back as you're working with boards and talking with boards. When you have those kind of in your brain, then you'll start to pick up on, oh, this might be a problem, and, you know, how are we going to work around this? So, you know, the explicitly differential rules are the easy ones, right? You know, we're not going to say there are no blacks allowed in our community. We're not going to say, you know, no one from Guatemala is allowed in our community. Those are those ones that just jump out at you. Those are the easy ones. And I would expect anybody who's been, you know, engaged in UCCAI or CAI is well aware of an explicit discrimination, you know, explicitly discriminatory rules right off the bat. It gets a little more complicated though when rules might not point out a specific group, but they affect a specific group. Will somebody push forward the slide, because I still can't. So, you know, I guess one difference would be adult only rules. So if you're not a HOPA community, those adult only rules, they're going to be explicitly discriminatory. They're going to be a problem. Even if you're trying to do lap swim hours, you know, rather than saying adults only from 6 to 8 in the morning, call them lap swim hours. And if you're restricting that behavior, then you're not going to get a bunch of kids who want to come to the pool and swim laps over and over. But you're not, you know, prohibiting them either. So that's how you kind of avoid that discrimination. Is anybody pushing the slide forward for me? No? There we go. So the rules that deal with kids are really probably the forefront of what we see regularly that people don't know are discriminatory. So leaving toys in the common area. I would suggest to you, we don't want anybody to leave any personal property in the common area. And that way you could have a rule that gets to the same effect without discriminating against families with children. Similarly, we've seen rules where chalk drawing is required to be rinsed off every evening, or, you know, commonly we'll see noise restrictions that are geared towards children only. Children must not make noise after 10. Well, do we want anyone making noise after 10? We would like the quiet hours to apply to everybody, not just children. So thinking through what you're trying to regulate and what behavior you're trying to get to with your rule is very important when you're crafting those rules. Why are you putting in force this rule? And is there a way to phrase it that isn't going to just pick on one protected characteristic? So if you want to advance our slide.
And Lauren, as you're jumping into that next one, so one of the perhaps the exceptions under the Fair Housing Act, there's been some interpretation of law in regards to like safety issues. So workout equipment. If there is a manufactured rating for a certain age, then you can follow that. Like, so if you have a gym in your common areas and the equipment says ages 16 and above or something like that, then that's one area where you're relying on somebody else's expertise that has said they've in essence created that safety issue. Pool is also unattended pool. That's one other area where they have indicated that you can, and I can't remember if it's 16 or 14 on the age on the pool. But that's one exception. But everywhere else, you have to, you don't call it children, you don't call it unaccompanied minors. You follow, like Lauren is saying, you just put the rule out there, and then if you don't want drawing on the sidewalk, well, then no graffiti or no drawings at all, not just children chalk art, so to speak.
Right. And I think you had, well, Arizona recently had kind of a timely issue with chalk drawing and children.
Yes.
There was, real quick, there was a question that just asked, can we prohibit chalk drawings? So let's talk about the chalk for just a minute.
Okay. Now, I can't remember if this was in Arizona or not. I just remember it hit national headlines, and it wasn't my particular case, but I remember seeing it and thinking, man, I am so glad that this is not my community that's getting this national attention. But during all of this shutdown, this lockdown, kids were out and they were coloring on the driveway, and just great, you know, uplifting messages, be positive, we can make it through this, and all these things. And guess what they got? A letter from the HOA saying, hey, sorry, you've got to remove your your stuff from the sidewalk, your artwork. And And so this family, they took it to the media. They're like, seriously, come on, we're all in lockdown here. We're all trying to just get along, and we're getting a letter from the HOA. So you don't want to be that poster child. You absolutely do not want to be the poster child for, especially in this environment.
But the question as to whether you can ban all chalk drawing, here's the example I would give. The HUD and UALD have made it very clear that rules that apply to bicycles disproportionately affect children. So, start looking for language that is geared toward non-motorized wheeled devices. So we don't want you to leave your rascal grandma out in the common area. We also don't want Junior's razor. We don't want any of that. So that kind of language is where you really need to be focusing. So rather than banning chalk drawing, you probably want to prohibit any alteration of the sidewalk or common areas, whether temporary or permanently, right? This way, you're getting at somebody who is taking a can of spray paint and tagging it, or a kid who is drawing with chalk. PR-wise, especially during quarantine, chalk drawing might not be the first thing you want to jump on, because kids are bored and parents need them out of the house at some point. But in the future, looking towards what are you really trying to prohibit? Is it just chalk, or do you want, any alteration on your sidewalks? It seems more than likely it's that latter. You really don't want anybody painting or chalk drawing or spray painting or doing anything. I mean, you don't want them to dig up a chunk of your sidewalk either. So focusing on that broader, more applicable language, focusing on the behavior and not so much, something that's going to pin a characteristic. Chalk drawing is pretty well correlated with children. So you want to step away from anything that's going to, spark HUD's interest in your rules. You want very, very uninteresting rules to HUD.
We have one more question that says, are we able to require kids be supervised in common areas? They used an example as a billiard room, just to make sure that stuff isn't getting damaged.
Yeah, so this is where it's safer to have a rule requiring someone to be, mature, but not put a specific age on it. If you are 12 years old and you're part of your billiards club at school, you're not likely to ram the cue down the felt top and destroy things. You probably have a great admiration, as opposed to a 21-year-old who is in there goofing off, showing off to his pals. Similarly with swimming, if you are 13 and you're on your competitive swim team, you're probably a lot safer in that pool by yourself than a 70-year-old person who's out there on their own, or somebody who's an adult but has never swam before, never had lessons, and they really don't know the first thing about it. So age can't always be that determining factor on your rules. There's got to be more behavior focused. So you have to look to what don't we want happening in the billiards room. We don't want damage. We don't want goofing around. We don't want people hitting the walls with the cues. And then you just have to regulate that behavior through warnings and your escalating fine scheme rather than focusing on the age. That's the only really safe way to deal with that.
And one example on the pool issue, you have a notice that the pool, there is no lifeguard on duty, and you swim at your own risk, and anyone swimming must be able to either be accompanied by somebody who is responsible enough to take care of them, or they by themselves must be able to handle swimming and the dangers associated with swimming. So if you focus it in on the behavior and on the safety issue, both billiards, swimming, whatever the case may be, as opposed to an age. I think that's kind of what we're both trying to really emphasize there.
Yeah, and it's not always easy or the most clear answer. Sometimes it takes really thinking it through. It takes the assistance of legal counsel sometimes, but if you are seeing rules geared toward a characteristic of a person, it's problematic. It really needs to focus on the behavior. Some are not clear at all. I would have never thought that they were discriminatory. No charcoal stoves. Is that discriminatory? Does anybody know? Because turns out it can be. So we had a community that prohibited charcoal stoves on the patios, and they had a good reason for it. You know, the charcoal falls down, it burns, it melts. There's some problems with that on these higher balconies. Well, there was a resident who was Muslim, and during Ramadan, they can't have any open flame to cook. So charcoal was the only way that they could make dinner. Now, the HOA had a very legitimate reason for this rule. It was safety, it was geared, and you know, if their rule was challenged, they likely could prevail, but you don't want to start down that road. You don't want to get to that challenge. So it's, you know, it was very easy to find a way, hey, can we have a certain area in the common area, a way where it's not going to cause any damage to have a charcoal grill for use for this purpose and avoid potential religious discrimination suit. So, you know, we were able to find common ground, but, you know, I had to do some research. Is this discriminatory? Is this somebody just making a claim that they need this for religious reasons just to have it? You know, it takes some digging in sometimes and expanding your cultural horizons. And it's not always easy. And I think the current status of our country and the world teaches us that there's lots we don't all know about each other and each other's cultures. So it's definitely an opportunity, rather than getting defensive about rules, to explore that and have that conversation. So
I've got one other off-topic question, but in the same vein of things. It is, can we ask a disabled person to be accompanied in the pool?
So again, that's targeting that characteristic of a person, and I would circle back to the language Brian gave us just a couple moments ago about if you are capable of swimming, self-rescuing, whatever that language is, otherwise you should be accompanied by someone who can help you. And you got to leave that up to them, let them assume that risk, but picking out a person based on that protected characteristic is going to be a problem.
Perfect.
Okay. Will you advance the slide for me? Perfect. Here's another common one. Brian had brought this up as we were working through this presentation. Religion is a big problem, and I sometimes when I teach fair housing in Southern Idaho for Rexburg, I like to joke about having, you know, student housing and not permitting any BYU fans. I mean, that's going to disproportionately affect people of a certain religion. So in Utah, can go the other way. We tend to have communities that are pretty homogenous, and sometimes using certain words or vocabulary referencing the stake or the church can make people feel unwelcome. I think that was, you know, something you had brought to light, and probably something you have more perspective on, going from Arizona and Utah and switching off, seeing the difference there.
Yeah, and you know, one of the things that we get asked quite a bit is, well, can we hold? We have a clubhouse, and we would love to hold a Bible study group or a ward potluck or something along those lines. And then the question becomes, can we do that? Well, you have to understand, if you open it up for any kind of group, whether it's religious or some other protected class, then you have to open it for all groups. and you have to be ready for that. So so that's one of the key issues to focus on. If you're going to allow certain things to happen, you've got to allow it for everybody and not just for a specific group. So a lot of times boards just say, the management committee just says, hey, you know what, we're not going to open it to anyone because we don't want to open that can of worms at all, as far as those types of situations.
Yeah, I dealt with a HOPA community a couple of years ago that wanted to hold a Christmas potluck, and they wanted to make it mandatory that everyone bring a white elephant gift. And the first thought in my mind was, you're excluding every Jehovah's Witness. They don't believe in exchanging gifts. This is, very problematic, and people who don't celebrate Christmas. So when that's management committee sponsored, it becomes really an issue. So go forward to the next slide. So let's talk about creating these rules. Of course, we want them written. And of course, we all know we need a written enforcement policy with those escalating penalties. Those escalating penalties are the best way to curb behavior. And when we go to court, to show that we've been reasonable with people who are offending. Hey, we didn't just slap a $500 fine on them. This started at a warning, then it went to 10 bucks. We've given them every opportunity, and now they're in the hole and they're not changing. That really helps an association win cases and recoup their attorney fees. So that's why it's so important, and why your attorneys will always reemphasize, have that written enforcement policy, stick to it, make sure it's applicable to everyone, and that it's really behavior focused, not pinpointing a protected characteristic, whether it's disability or age or religion. It's really behavior focused is what will save you, and avoid any FHA complaint.
And those FHA complaints are not fun to deal with. For those who have had to deal with them, we had one just a few weeks ago where the homeowner filed a complaint saying they're targeting me because of my race, I believe it was, on this one. And so the Attorney General's office got involved and started pursuing a complaint against the association. And they got our office involved, and we were able to pick up the phone and talk to the Attorney General's office. And we immediately asked our client to produce a list of all the violations that had been sent over the course of the last 6 months. And because they had good records of the information they had sent, we were able to pull that, provide it to the Attorney General's office, and show that, of the other violation letters that were sent, that a percentage of them were also in a protected class. And when they saw globally how many letters were sent, they dropped the case immediately. So that documentation is key, as Lauren mentioned.
Yeah, I mean, Brian hit it, and it's definitely in the next slide when we talk about enforcement. Keeping detailed records is absolutely key. We had a similar situation with somebody claiming they were only getting fined because of their national origin, and the management company just exported every fine letter they'd been sending, and we could show that people of the similar last names, similar regional bases were getting fined just as often, and also every Christensen, Baker, Campbell, Carpenter, Morgan, they were all receiving even more fines. So there was no targeting. It was a successful defense. It really didn't have to get too much beyond that. You want to make sure that it's always uniform. So don't skip a step in that escalating policy for some people and not for others, because even if you don't mean it to be discriminatory, there's a chance that that's where the dice falls, that's where the cards lay, and when it comes time to show that you were not selectively enforcing, you may not be able to do that. So it's really important to keep that enforcement uniform. The other issue is, oftentimes we will suggest to an HOA to require corroborating evidence before issuing fines or taking any enforcement action. We had a community where one woman was claiming that her neighbor was harassing her because she was a woman. And not only that, but the HOA was refusing to enforce the rules against harassment because she was a woman. The HOA had a policy of requiring corroborating evidence for any offense that wasn't personally observed by the property manager or the HOA board, and that was enough to get the parties to resolve the issue, absent of getting through the whole investigation of UALD or HUD, requiring that corroborating evidence. Because once a neighbor doesn't like another neighbor and they start making complaints, and there's that lack of corroborating evidence, it can be very difficult for a property manager or a board to determine whether they're hindering harassment or helping it. It can be a very fine line, and without that substantiating proof of a violation, you could be unwittingly harassing or helping to harass another neighbor. So I think, yeah.
I do have a question that has come in. It says, you've mentioned escalating fines a few times. Is there a reason that is simply that is the best practice, or why is it the best practice?
So I think it's the best practice for a couple of reasons. And I mentioned one, in that really allows us to show the reasonableness of the HOA if we ever get to court. If we have somebody who's been fined, we need either an injunction to stop the behavior, or we're pursuing a lien foreclosure, something like that. Being able to demonstrate to the court that, hey, this is against the rules, and we didn't just slam a $500 fine after $500 fine to rack up a huge bill to then foreclose on their house, which is commonly what these defendants will claim. They're just fining me so they can take my property. Hey, we started with a warning letter, then a $10 fine, then a $25 fine. We were really keeping it as reasonable as we could, and they just kept doing it. They just kept violating this provision, wouldn't stop. That enables us to show how reasonable the HOA is in approaching enforcement, and that it's not simply a land grab to get their unit away from them. That also helps, it showing that reasonableness helps get the attorney fees recouped. It also helps focus in behavior. So sometimes if you jump to a giant fine immediately, you get somebody mad, you get pushed back, you end up with a hostile situation. Starting with a $10 fine, if they don't stop, a $25 fine, just working it up until you find that pinch point where it hurts enough that they're willing to stop, is a lot more beneficial, and they're less likely to make that claim of, you're coming after me. They start to see it's their behavior. I think that is more influential and more persuasive in them deciding to change their own ways, change their behavior.
And I would just chime in and say, I agree with Lauren. I think you always want to take a reasonable approach. The one area that you've heard both Lauren and I kind of comment on throughout the course of this meeting today is safety issues, so health and safety. So the way I look at things, you create rules and regulations not for the people who comply, but for the people who don't comply. And sometimes you have people who are the antisocials, or the ones who are they're going to do whatever they can to push against the rules and regulations. And really, it's those are the ones.
Associations.
What's that?
People who shouldn't live in associations.
Yes, exactly. You know the rules. When you got into the place, you knew the rules. Just abide by them. But in those kind of scenarios, I always encourage my clients to have a policy that's flexible enough that you can show that reasonable approach. But if you have to jump on somebody hard and fast because of a health and safety issue, then you do it. Sometimes you're going to have to weigh that balance of, do we run the risk of potential discrimination issues, or do we really need to stop action very, very quickly? And so those are some of the business decisions that as a management committee they'll have to make. Where do we find that risk, and what's our level of risk tolerance? One other item in regards to establishing those rules, as Lauren said, you want to have, in most cases, an escalating policy, but you can also consider the type of violation and how that policy should escalate. A couple examples: parking an RV out in front of your home. If you have a fine of $10 and then going to $25 and then $45, well, somebody's going to say, hey, it's going to cost me way more than that to store my my RV, so I'll gladly write the check every month for those escalating fines, and I'll keep my RV there as long as I need to during the months that I'm using that. So there's no problem with, and depending on the type of violation, having it hit the pain point faster, as long as it's uniform and as long as you're saying, okay, anyone with RVs, not just we're focusing on this one person, but RVs is going to be a little bit different class. We're going to start the fine at $100 or $250, or another one is Airbnb, or VRBO, Airbnb, short-term rentals. If you have a $10 and a $25 and a $75 fine, well, they're making, in some cases, thousands of dollars a night. So they're going to be like, okay, again, checkbook, here you go. That's just the cost of doing business, and I'm going to continue to violate all I want. So for those type of violations, it may need to be more aggressive at the outset, but again, having that uniformity where everybody is in the same situation. You're not escalating just on one particular household or one individual.
But make sure if you're going to carve out certain conduct or certain behaviors for a different fine schedule, a quicker scheme, it needs to be in your rules.
Yes.
I've got a few questions rolling in here. This one's a little wordy, so give me just a second. I'm just gonna go ahead and read it. I managed communities that tend to have a lot of investors. When issuing fines, owners claim that they didn't get them because their address wasn't correct or the tenants didn't get the information. How can we be flexible without waiving every fine? Because if it's waived for one person, right, we're discriminating in that sense, since it should be the same for everyone.
Yeah, so I would point you to the acts, the Community Association Act and the Utah Condominium Ownership Act, and I would suggest to you that owners are required to get notice. So giving a tenant notice is probably not enough. And honestly, sending the owners the notice and the fines is more likely to curb that behavior or get a better tenant in there than sending it to the tenant themselves. Once the owner starts to feel that pressure from the board and it starts to affect them, they will start pushing on their tenants. So if you can, post it on the door, email it to the owner and mail it, the owner is getting an HOA invoice somehow. What address is that going to? Starting to push back on who's paying those assessments and how they're getting notice of those assessments, and comparing it to where those fine notices are going might be the first place to start.
Perfect. Brian, did you have anything to add? I've got 3 questions.
No, I agree
Okay.
with that.
Next question was a rule about children. Can we establish a rule about children under the age of 2 years old being in the pool? And what about diapers, and how does that fit into it?
So diapers is a great example because small children are not the only people who wear diapers. So your rule doesn't need to pick out a certain age. It can just be about diapers, because that's a safety issue, it's a health issue, it's important, and you want that to apply to great grandma's diapers and every little baby's diapers across the board. That's a health and safety issue, but you can approach that without hitting that character, that protected characteristic. As far as children under the age of 2, I don't know how you approach this, Brian. Most of our pools in community associations in Utah fall under the health department. And so if you can reference the health department and really just let them take the brunt of what's allowable. It really takes that risk away from the HOA while still being enforceable.
Yeah,
Through
absolutely. I'm always about shifting that burden of enforcement and that burden of liability for those types of issues. So if you can point to health safety issues, and one of the rules may be that we comply with all of, if you're in Salt Lake County, all the Salt Lake County guidelines for operating pools. And if they have specific guidelines to talk about that, then you're not the one imposing that. You're just trying to help establish the fact that Salt Lake County has established some guidelines, and you're complying with those as well.
That's awesome. Next question is, can the fine change based on the severity of the violation?
Yes. So as both Laura and I have mentioned, it can change on the severity of the violation. If you have a schedule of fines, then you want to make sure that you can have different categories. So you can say, category A is minor infractions. Category B are infractions that involve health and safety. Category C are fines that need immediate attention. So you can do it that way. You can list out certain things that you have within your community that you see areas of concern over and over and over again. Or you can have a fine policy that's broad enough to allow, this one is a little more risky, but you can have a fine policy that's broad enough to allow the board the management committee to evaluate it on a case-by-case basis. But that one, then you start running the risk of improper treatment for different individuals. So I wouldn't recommend that last one.
Great. Last question. I tried to get a little bit of clarification. I should have asked it a little bit sooner, so I apologize. The question is, what's the citation for the Community Association Act?
I'll have to look that up. Give me, 1 second. So while I look that up, you can talk about it.
Perfect.
Lauren will get back to us on that while I'm kind of focusing on that. So group homes, I love this little slide. This is the Gary Larson from The Far Side. And I don't know if this is true, but I remember growing up and my brother told me that Gary Larson just lived down the street in Sugar House maybe. I don't know if that was true, but but anyway, I love The Far Side. And you read this, if there are monsters moving in next door, Danny, you just ignore them. The more you believe in them, the more they'll try to get you. I can just envision this little kid like freaking out that these people are moving in next door. Well, sometimes group homes have the same impact, the same feeling. I can't tell you how many phone calls I've received from either boards or committee members, managers saying, "Hey, Brian, we've got a huge problem." I'm like, "Oh, tell me what's going on." Yeah, we just found out there's a group home in our community. Oh, okay. Tell me more. Tell me more. What kind of group home? Well, it's a group home for the elderly. Okay, all right. So yeah, tell me what's going on. How long has it been there? Well, I think it's been there like 10 years. Okay, and you just found out how? Well, the owner was at one of the parties, and he just let it slip that he has a group home. Okay, so any concerns behavioral? No, didn't even know it was there, but it's there. What do we do? So there's this stigma of there's a group home, something must be wrong, and we've got to do something to protect our neighbors from this group home. Well, there are a lot of different types of group homes, and many of them are protected under the Fair Housing Act. We have listed here several types: elderly, drug and alcohol rehabilitation, hospice, sex offenders, anger management, high cholesterol, eyeglass wearers. I literally found one where there was a group home for people who wear eyeglasses. So it's like, come on. But there are all types of group homes. And so the question, going back to what we started out at the beginning, focusing on behavior, focusing on what is causing the problem. Under group homes, typically what the common violation is that they're operating business out of the home, right? That's the first thing that people say is, hey, they're operating a business, we need to shut them down because so-and-so can't operate their business. We've got somebody who is having piano lessons from their house, and we had to shut them down because of the constant traffic in and out. So what about group homes? Well, the laws that have developed in the case law under Fair Housing Act, it's made it very clear that group homes are absolutely allowed. And so you must make an exception to your rules and regulations regarding operating a business from your home. That one, that's unquestionable. If it is a protected group home, elderly is protected. The drug alcohol rehabilitation is protected as long as they are not current users of alcohol or drugs. So those are a couple ones that are protected. Anger management, not necessarily. That's not a protected class. Sex offenders, not a protected class. So those you can prohibit without running afoul of the Fair Housing Act. And the others that have protected status under the Fair Housing Act, you still can establish rules and regulations. So you're not powerless. You can also, and like we've focused on all throughout this morning, your rules should focus on the behavior that is unwanted. So if the behavior involves parking, you have too much parking going on, well, then enforce the parking restrictions. If the behavior is in regards to architectural structure, if they're making changes to the building, to the house without getting approval from the management committee, contrary to the rules, well, that's a violation. Have them get approval. Now, if they're asking for a ramp, you're going to have to give it to them, but you may be able to help control where that ramp is placed and the aesthetics of that wheelchair ramp. So focus on the behavior of what is problematic, and then you can pinpoint those issues and get them resolved. Some of the common violations we receive: illegal activities, single-family home, business from home, architectural issues, parking restrictions. Another one that we see all the time is people want to try and get as many beds in there as possible. So they may violate county restrictions on how many people can be in a house. That goes back to Lauren's comment earlier. Well, then get the county involved. Have them come in and enforce that provision. You don't have to be the bad guy in that situation. They may try to convert a garage into another bedroom. If your documents prohibit the conversion of garages, well, then they don't get, just because they're a protected class, it doesn't mean they get to violate that provision of the documents. You can absolutely shut that one down and say, no, you don't get to convert your home. No one else gets to convert their home. The purpose of the Fair Housing Act is to allow those people who are disabled or protected to have the same benefits that everybody else in the community has. And so that's kind of the we focus on that. I think that's it on that one.
Oh, we can't hear you, Ryan. So section, can't hear you.
Sorry, the phone was ringing, so I muted it. I just said the last question about the single family home dwelling, does that impact the group status? You answered that. So we'll go ahead and mark that as answered. If you have more questions on that, Elizabeth, just let me know. Lauren, go ahead and answer your question, or answer that question.
Yeah, see, being home for too long, somebody calls me on not remembering my statutes, but Section 208 not only requires that first written warning to go to the lot owner, but the appeal process to request an informal hearing is actually triggered based on the day the lot owner receives the notice. So throughout that section, it talks about finding the lot owner, and I know a lot of our governing documents talk about allowing the HOA to find a tenant as well. But really the statute focuses on that lot owner and all of those key points, the written warning, the appeals process, that all comes from notice to the lot owner. So not just the tenant. Perfect. So I know we're about out of time. Ryan had suggested that we talk pretty quickly about quid pro quo harassment, not just quid pro quo, but harassment in general, just given some escalating tensions in communities that he's seen. I personally think quid pro quo is pretty easy. You know, until I saw a property manager back in Illinois who had been reducing amounts owed for women based on the exchange for sexual behavior. Curiously, he's never allowed to be a property manager again. That was part of his court sentence, along with many millions of dollars in fines. He can never manage another property again. So just, don't exchange sexual favors with your residents, guys. It's just never a good idea. But also, when you have other managers or assistant managers, watch for questionable behavior or suspect situations. Usually you can pick out when things are not really shaken up, things are not right. There's an account that's chronically delinquent, but no enforcement action is being taken. This is something to start looking into. So if you'll forward one, yeah.
One other area I see a lot of just the harassment is after a fair housing violation complaint that is lodged, and we get involved to help resolve the issue, and we finally resolve it. I'll have sometimes either a manager or a committee say, hey, can we go ahead and add your attorney fees back onto their account? And that's an absolute no. You can't do that. The minute you do that, you're going to get another complaint, and that one's going to be successful against the association. So
yes. I'll just very quickly hit on what I think, Ryan, your question probably was about harassment. And if you have harassment that you're aware of between protected class, against someone of a protected class, and you're aware of it and you have the power to take some action, or the HOA has some power to take some action, you are legally obligated to do so. You may violate the Fair Housing Act by not stepping in. So you can't always police every neighbor incident. Not every neighbor dispute rises to the level of a Fair Housing Act violation. But if you see and are aware of harassing behavior based on a protected characteristic, and you can deal with that through some sort of nuisance provision, you really should look into doing that to protect the HOA. Okay.
Perfect. I did have one last question, and it was regarding discrimination and allowing or residents, thoughts on residents displaying LGBTQ flags in a community, and where should we stand on that as property managers?
That's what your rules are about flags.
Yep. So I've dealt with several of those. Most recently, I mean, it's somewhat synonymous, but a lot of Black Lives Matter issues coming up in the last few weeks, and had two cases in particular. There was a group of people standing on common areas with posters and signs, and the manager contacted us and said, hey, what should we do about this? Another one where they had a view fence and they had a Black Lives Matter sign posted. And again, we kind of, that really is akin to the LGBTQ, the rainbow flag. We had one where they had the United States flag on one side and the LGBTQ flag on the other side, just draped on their windows, very prominently. And like Lauren says, you have to look at your rules. What are your rules? And you have to enforce equally. And so if your rules say no signage, then no signage, and enforce that. Now, one thing that the manager I spoke with just a couple of days ago about the Black Lives Matter sign, it was a small sign. It was not displayed really prominently, but she was petrified to do anything at this moment. And just because of the political climate, afraid that she would get blowback. She had a homeowner complain about it and say, oh, it looks like we get political signs now, so either that sign goes down or I start putting my political signs up. And she was like, what do I do? And in that situation, well, when's your management committee meeting? And she said, well, I have one tomorrow. I said, great. Well, that's not on the agenda, so don't put it on the agenda. Get back with the homeowner that complained tomorrow after the meeting and let her know, thanks, I'll bring it up at the next meeting, which is not till the end of July. And by then, hopefully the political climate will dissipate a little bit, and then they can go into more of a standard enforcement mechanism of, and in fact, the manager said, I wouldn't mind just calling the homeowner saying, hey, you know, signs aren't allowed. We appreciate the message, or we're sensitive to the message, whatever. But as an HOA, you don't take political sides. That's not our role. You enforce the documents as they're written. You evaluate fair housing issues. Is there discrimination? There's no right to put a sign up displaying. So depending on what your documents say, then you enforce them sensitively and in a way. If you need advice and help of legal counsel to navigate through that, then that's what we're here for.
And if you do that, then make sure you are on every single AAA pest control sign or True Green lawn sign that gets stuck in somebody's lawn after they perform a service. Really make sure that you are enforcing against every violator. You're going to want to be able to show that.
Perfect. Looks like all the questions, and I think we're wrapped up. So I'll turn the time back over to Mindy.
Okay, yeah, thank you so much. This was a fabulous presentation. I think we got a lot of valuable information. It was great to have the banter back and forth and the questions and keeping it really interactive. This is one of the beauties of this format. And just a quick reminder that our next webinar will be September 25th on insurance. Thank you again to Brian and Lauren and Ryan. Appreciate all of your efforts on this. It was a great discussion, and thank you. Join us again next time.
Thanks,
Stay
Mindy.
healthy, everybody.
Yeah.